Hello friends, welcome to AVISION for CLAT and other government jobs. So, in today's class, we are going to learn about defamation. So, as you all know, in our channel, this is a specialized channel for CLAT and other law entrance exams. So, if you are preparing for CLAT, AILET, SLAT or any other law entrance exams, then this channel is for you. So, today's discussion will be on defamation. So, let us first understand the meaning of defamation. So, let me first tell you from where this term came. This term came from the word defame. So, this term came from the word defame. So, what is the meaning of defame? Defame means to insult any person or to cause injury or to harm the reputation of any other person. Just suppose I did something and out of my act, anyone else's reputation got harmed. So, I harmed someone else's reputation. Okay. So, what did I do? I defamed that person. I defamed that person and I committed defamation, which is a tort. So, under law of torts, defamation is a civil wrong. So, if I commit defamation, if I result or if I do any harm to the reputation of any other person, then I commit defamation. Okay. So, this is the concept of defamation. Now, we will understand what are the essentials. So, what do you mean by essentials? So, these are the 4 essentials that you need to fulfill, that should be fulfilled if you want to say that, this act is falling under defamation, or if you want to say that this person has committed defamation. If you want to say this, then you will have to see if these 4 ingredients or if these 4 essentials are fulfilled or not. So, you will have to keep this thing in mind. Now, let us see what are the essentials. Number 1 is you will have to prove that, or the plaintiff. So, we know who is the plaintiff and who is the defendant. So, who is the plaintiff? Against whom this defamation has been done or has been committed, means whose reputation has been injured. So, the injured person who files a case against the wrongdoer or against the person who has defamed his reputation, he is the plaintiff, and against whom the case has been filed or who commits that defamation is the defendant. Okay. So, plaintiff needs to prove that publication of a statement. So, plaintiff needs to prove that the statement was published. So, what do you mean by statement here? Here, statement means Just suppose the harm of defamation, or I injured the reputation of another person by some statement. So, it can be oral, it can be written, but it should be a statement. I can say something, I can say some defamatory words, or I can write some defamatory statements. So, if I say some defamatory words, there should be publication. There should be publication. So, what is the meaning of publication? Publication means when something or this defamatory sentence, these defamatory words that are spoken in front of the public. Okay. When I publicly defame someone, when I publicly say some defamatory words to any person, then the defamatory statement has been published. So, when the defamatory statement is publicly made by the defendant, then the statement is published. Or in other words, I can also say this falls under oral defamatory statement. But what will happen in case of a written statement, written defamation? Then you will have to say it has to be published in a newspaper, okay, newspaper. So, if anything is published, if any defamatory statement or any defamatory article is published in a newspaper, then it is published. Okay. So, the first requirement is publication of statement, publication of the, let me say, defamatory statement. So, the defendant statement, yes, see the second point is only that, the second point is statement must be defamatory, written, oral or printed or a picture, anything it can be, but the statement has to be defamatory. What does it mean then? The statement has to defame some other person. Statement has to injure the reputation of the plaintiff. So, if it is found that there is no injury to the reputation of the plaintiff, if it is found that there is no injury to the reputation of the plaintiff, then there is no defamation. Alright. Number 3 is the said statement must refer to the plaintiff. So, again the plaintiff must prove that the defamatory statement that is made by the defendant it must refer to the plaintiff. So, the plaintiff has to prove that the defamatory statement made by the defendant must refer to the plaintiff. So, this is on to the plaintiff to prove. Okay, what is next? The statement must be published. Yes. So, again publication. So, the statement has to be published, maybe it is spoken words in public in front of everyone, that is also a defamation. So, spoken words can also be published and written words can also be published. Written words can be published in a newspaper or anything which is publicly read, which is read by the public. And spoken words, how spoken words can be defamatory? When the words are spoken in front of the public, in front of a group of people, in front of everyone, that is also a defamation. Okay. Now we will see two case laws. Okay. there are two very important case laws, two judgments, two landmark judgments which prove the defamation concept. First one is D.P. Chaudhary versus Manjulata and South Indian Railway Company versus Ramakrishna. So, these are the two landmark judgments that you need to learn, that you need to go through if you want to understand the concept of defamation clearly. So, what happened in D.P. Chaudhary versus Manjulata? What happened? Let us see. In the first case, it was held that there was a local daily, okay, there was a local daily, or you can say newspaper, local newspaper called Dainik Navjyoti. Okay, so there was a local newspaper called Dainik Navjyoti, and what happened? This is a case of Jodhpur, remember, this is a case of Jodhpur, and what happened? What happened? Okay, the date was around 1812-77. So, as this is taken as a landmark judgment, you must go through this. Now, in this case, there was a girl, okay, there was a girl called Manjulata. She was 17 years of age. She was 17 years of age. She belonged to a reputed and educated family. She belonged from an educated family. And what happened? She herself was also educated. She was a BA, Bachelor of Arts. She was a BA. Now, what happened? Now, it was published in this newspaper, Dainik Navjyoti, in Jaipur, which was a local daily. What was published there? It was published that this Manjulata, she went out of her home at 11 p.m. at night she said that she went out for her classes. Okay. She said that she went out for her classes, but it was written there, it was written in the newspaper that she ran away with a boy, named Kamlesh. She ran away with a boy named Kamlesh. Now, what happened? This was a fake news, okay. As this was a fake news about Manjulata, so this news affected Manjulata, and it also affected her marriage prospects. So, this kind of a bad reputation is a trouble for a girl of 18 years of age. Obviously, because after all, she is going to be married someday or the other. So, this news is going to affect her marriage prospects. So, basically we can say that she was defamed by this newspaper Dainik Navjyoti. She was defamed. Injury has been caused to her reputation. So, this newspaper Dainik Navjyoti, it committed defamation, it committed tort. So, Manjulata sued the Dainik Navjyoti company, newspaper company, and she got damages of rupees 10,000. So, at that time in 77, okay, in 1977, she received an amount of rupees 10,000 as compensation from this company. All right. So, let us see the next case. The next case is South Indian Railway Company versus Ramakrishna. So, what happened here? There was a railway guard, okay, railway guard. There was a railway guard, and the railway guard was the employee of the South Indian Railway. Railway guard was the employee of the South Indian Railway. Now what happened? He was checking tickets. The railway guard was checking tickets. Checking tickets in the train. Okay. The railway guard was checking tickets in the train. Now what happened? Now what happened? That the railway guard was the defendant. Okay. The railway guard who was checking tickets was the defendant. And who is the plaintiff? Who is the plaintiff then? There was a man in the railway compartment. There was a man in the railway compartment whom the railway guard said to the man, this railway guard who was checking tickets, he told that man that I suspect that you are travelling without ticket. The defendant said to the plaintiff, or the railway guard said to that man that I suspect that you are travelling without ticket. You are travelling without ticket, or you are having a fake ticket. Okay. Defendant said to the plaintiff that you are having a fake ticket, or I suspect that you are not having a ticket, you are travelling without ticket. Now what happened after this conversation? The plaintiff took out his ticket and showed it to the railway guard who was the defendant, showed it to the railway guard that see, I am not having any fake ticket, or I am having a ticket. Okay. I am not travelling without ticket. So, the plaintiff showed the defendant her original ticket. Now, what happened? As the railway guard told the defendant, as the railway guard told the plaintiff or the man, in the presence of everybody, in the presence of all other passengers. So, what did he do? He publicly defamed the plaintiff. He publicly injured the reputation of the plaintiff. He publicly said that you are travelling with a fake ticket, or you are travelling without ticket. So, if someone tells me this kind of a thing publicly in front of everyone, then what will I do? Obviously, I will sue him. So, in this case also, the plaintiff sued the defendant. The man sued the railway company, okay, the South Indian Railways. The plaintiff sued the South Indian Railways. But what did the Supreme Court say in this case? In this case, the Supreme Court held that the railway guard, who was the employee of the South Indian Railway, cannot be held liable for any damages. Why? Why? Because he was doing his duty. Because he was doing his duty. It is the duty of a guard, of a railway guard, to check the tickets and to say that to suspect anybody, this is included in his duty. So, in this case, the plaintiff was not liable to get any compensation from the defendant because he was doing his duty. Okay? So, in this case, no defamation occurred because this was the duty of the railway guard. It was not his intention to defame that person. It was not his motive. He was doing his work, he was doing his job. So, no defamation occurred in this case. Okay. So, I guess both the cases are clear. I guess both the cases are clear. Now, these are the two cases that you should go through when you are learning, when you are reading defamation. So, defamation concept, I guess I was able to clear the concept of defamation, and for more concepts of law of torts, please watch our other videos and you will find other concepts of torts also in our other videos, and watch our other videos to clear the concept of tort very well, or tort or any other law subjects such as constitutional law, or there is international law, there is law of crimes, whatever it may be, you will find videos in our channel. Alright, and don't forget to subscribe our channel, and don't forget to hit the like button, because bell button, because you will get all the updates regarding the videos. Thanks for watching. Thank you.